Now, moving into our first panel, Bettering the Justice System, Opportunities for Reform. We'll hear from national policy experts about how policies impact the color of justice. I'd like to introduce our moderator, Michele Worobiec, founder and CEO of Silta Strategy LLC and an OSBF Fellow from the class of 2022. Michele is an international author, speaker, and consultant. Previously, she served as a magistrate and acting judge for Marion Municipal Court and as policy counsel and state drug court coordinator for the Supreme Court of Ohio. Michele, welcome. Take it away.
Thanks, Judge. It's an honor to be a part of this event and to lead our next discussion. Let me introduce our team of panelists. First, from New York, we have Brandon Buskey. He is a director of the ACLU's Criminal Law Reform Project in New York. He was previously deputy director for Smart Justice Litigation. Brandon's work focuses on reforming pretrial justice, regaining community safety and policing, and expanding the right to counsel and access to quality public defense. I'm also pleased to welcome to the panel today Kyle Strickland, who is a senior legal analyst at the Kirwan Institute for the Study of Race and Ethnicity at The Ohio State University, where his research focuses on equitable civic engagement practices, criminal justice reform, and racial equity initiatives. In addition, Kyle serves as a director of My Brother's Keeper, Ohio, which is a statewide network that provides educational and community opportunities for youth of color. And finally, we have Paula Hannaford-Agor, who is the director of the Center of Jury Studies in Williamsburg, Virginia, where she joined the research division of the National Center in May of 1993. In this capacity, Paula regularly conducts research and provides technical assistance and education to courts and court personnel on the topics of jury system management and trial procedure, civil litigation, and complex and mass tort litigation. So on behalf of the Ohio State Bar Foundation, I want to welcome all of you to today's event. Unfortunately, we were not able to fly you here, so this is a remote session, but we are thrilled to have you as part of the discussion. I'd like to start off our policy discussion with something that we heard Laura and Carlton discuss earlier. And they talk some about systemic or structural racism. Kyle, I know that's part of your work. So would you be able to share with us, what do we mean by structural and systemic racism, and what work have you been doing in this area as it relates to the justice system?
Of course. Thanks so much, Michele. It's great to be here today. Great to be on with such a phenomenal panelist. So when we talk about structural racism or systemic racism, those terms are often used interchangeably. They're slightly different terms, but for purpose of this discussion, it mostly refers to the ways in which our society is structured, the ways that laws, policies, and practices structure and shape or perpetuate inequality and discrimination. It's why, when we look at the work, when we talk about things like systemic racism, structural racism, we have to also include and understand our history. It is the ways in which a history of policies, a history of discriminatory practices has led to where we are today that continues to produce unjust and unequal outcomes. In the work at the Kirwan Institute, we really focus on two main lenses for this work. The first lens is really this lens of implicit bias, so kind of that interpersonal level, thinking about the way in which our individual thoughts and actions can play a role in maintaining discrimination, whether that's implicit or explicit. And then we also need to talk about this deeper lens when it comes to structures and systems. As a large part of the discussion was talking about, these structures show that the ways in which our laws, our policies, our practices, our history influences where we are today is why we still see so many disparities. And it's also why these disparities are deeply entrenched. And so a lot of the work that we do within the context of the criminal legal system, we do work with communities. So our work is very much evidence-based, research-based, but also applied research. So it's not just about researching the data and making sure that that just sits on the shelves, but also being engaged in community. We've done a lot of work with the MacArthur Foundation, for example, and their Safety and Justice Challenge. But one of the things that we've identified and that they've seen as well, different systems partners have seen, is that you might work to reduce the local prison and jail population. But what happens when those disparities, when racial disparities increase because Black and brown people are not having the same access to those diversion programs, those alternatives to incarceration. And so when we talk about structures, you have to think about history, from the history of redlining and lending discrimination to a history and policies of mass incarceration that has led to, of course, what Michelle Alexander talks about as the new Jim Crow when it comes to systemic racism in our society.
And Kyle, so it sounds like you're not implying that our court system or our legal system was created to include racism. We're really looking at maybe some of the unintended outcomes as a result of the justice structure that we have right now. So
there's a lot of pieces that come into the play when we talk about the structures in which our court systems operates, what our society operates. Some of these policies and practices are done in ways that lead to unintended consequences, whereas others were very much structured and designed to perpetuate discrimination over time. And so as much as we've tried to root out those vestiges of discrimination, of a legacy of racism and exploitation and oppression, there are still vestiges that still persist to this day, which means that even if folks have intentions, that they are trying to have a lens of equity, of inclusion, because of these structures, these institutions with a history and a pattern of discrimination, it can perpetuate to inequality today. So there's a lot of work that we have to do, both on the unintended consequences, but also even reflecting on past practices that were intentionally designed to exclude and exploit entire communities.
And so, Kyle, I thank you for that introduction. I want to shift the discussion a little bit, and Brandon, I'm going to maybe have you make some comments. I hear among some of our colleagues that they feel like, well, if we have structural or systemic racism, maybe one of the ways to get around that is through having discretion. And that gives you room to kind of maybe do the right thing that sometimes structure can impede. But we know that's not the perfect answer either. So, Brandon, can you talk a little bit about what we realize, the judges, the prosecutors, the police officers, when they are expected to exercise discretion, how that can also result in some outcomes that are not desirable?
Sure. It's a critical question. And I really appreciate Kyle's response on the structure issue. And I think that as we recognize here, even if you were to solve the structural issues, your systems and structures are really only as good as the people who are implementing them. And so to your question, what we've seen is that discretion can work and can be a part of this solution, but it's got to be really intentional and really guided. And so to give you an example of a place where we've seen this work, I work a lot on bail, and we've seen bail reform in a number of different locations throughout the country. One of the most prominent in recent years has been in New Jersey, and that's a place where we've really seen careful attention to both the structure of the bail system, but then also how discretion is used within that system. And perhaps more importantly, and what's really helped that system thrive, is a commitment to a culture of release among those judges and prosecutors and others who are charged with carrying out the system. And so you have a place where the bail determination is really scrutinized. Judges have to make very careful findings if they're going to detain someone. They're being charged with limiting the amount of cash bail that they impose so that people are not detained inadvertently because they simply can't afford to purchase their release. And by and large, judges within that system are holding to not only the structure, but the intent to increase release. And we're seeing release rates of well over 95%, and also doing that in line with public safety. And I think that's a place where discretion really works well. And that's a place where, one, that discretion is guided very carefully, but two, where the actors in the system are all bought into the central purpose of liberating individuals and making sure not to visit the harms of pretrial detention unnecessarily. So that obviously then leads us to the downsides of discretion and the limits of discretion as a fix here. And I'll stick to the pretrial setting, because what we've seen, despite the success of places like New Jersey and New York and Washington, D.C., all these places where we've seen release at a higher level work and encourage public safety, there's been a backlash. And so now you have judges very worried about the risks of pretrial release and the proverbial risk that if they release someone, that person is going to go out and commit a horrific offense while out on their bail order. And that's where we see the downside of discretion is you have judges who become risk averse and then abandon the underlying purposes of the system in order to avoid bad consequences. And, part of that is this risk aversion I talk about. Part of that is implicit bias, as Kyle mentioned. But then also, I think it's important to realize that we can't separate the discretion from the structure. And it's tempting to talk about them in different ways. But when you think about, in particular, judges in pretrial detention, what you've really got is a built-in structural problem with how they use discretion. It's a dysfunctional feedback loop, as I call it, where a judge, as I mentioned before, will always know when they've released someone improperly. That person will go out and commit an offense. They will go out and not return to court. But judges never learn if they've detained someone improperly. And think about how we learn, right? Just as ordinary people, you have to get feedback to know when you've made a mistake. And yet our system is structured in a way that when officials like that use discretion improperly, they never get that feedback that you actually made a mistake. And they very rarely get the feedback that your sentencing decisions or your bail decisions are actually having this impact based on race or gender or disability or whatever in order to make those corrections. And so while we can have training, we can try to bring out the best instincts of judges, without that feedback, without telling them how to better curate their decisions, we're simply going to have those similar instances of using discretion improperly and over-detaining individuals.
You've brought up so many important points, and I think we hear a lot about the unintended consequences. So what we know is the community is asking for safety, right? The community is asking for correction in behavior. We have a justice system that has due process and right to counsel and all kinds of rights built in, but we know our structure still doesn't have perfect results. We try to have discretion to make sure that we can make accommodations for those areas where the structure may be lacking. And I appreciate that in addition to looking out for the public interest, we also need to look out for the rights and the interests of those that have been accused of a crime. It's a really delicate balance that we have. Paula, I want you to be part of this conversation also. And so we heard from your introduction about your work in jury trial processes. Can you explain to us how these concepts show up in our trial by jury?
Yeah, so I was thoroughly enjoying both Kyle and Brandon's description. And I always look at the jury as it's kind of a microcosm of the entire justice system. In some ways, trial by jury is probably the most structured and heavily guided, carefully guided decision-making throughout the criminal justice process. So you have jurors that not only are not making individual decisions, but they are placed in a position where they must make a unanimous decision among, depending upon the state you're in, whether it's a 6-person jury or a 12-person jury, but requires that interaction of discussion of the evidence and the law and coming to a common consensus about what inferences you make from the evidence that you've heard to arrive at a verdict. And so that actually has sort of a countervailing impact on individual discretion. The individual implicit biases that any jurors may bring to bear when they are confronting their fellow jurors in the process of deliberating. They are exposed to, well, I didn't actually understand that he said it that way, and my impression was that in that sort of situation, I would have reacted in a very different way. And so you actually have that discussion that brings out and checks a lot of the assumptions, the biases that often can cloud decision making from individual people who are making them, really kind of on instinct. So that, I think, is a really beneficial aspect of jury trials. Again, it's unanimous. So at the end of the day, you actually have to have convinced the other people that everybody agrees on what the outcome of this trial should be. And as Brandon was talking about, is sort of having the guidance. We have jury instructions that are very detailed. And so jurors are told that, not only do, you have to, you may only convict if this element of the crime and that element of crime and this element of the crime is proved beyond a reasonable doubt. And so we have burdens of proof, and we have specific objective criteria that the jurors actually have to pay attention to. And we know from a lot of jury research that they are extraordinarily conscientious about that process and very careful about that process. So there is a lot of structure that's involved. There is a lot of guidance that tempers some of the individual decision making. Probably the biggest weakness is the fact that jury deliberations are a black box. And there are very, very few instances where people have the opportunity to kind of peek inside and hear about how jurors actually went about making their decisions. And were they working from like a clearly erroneous understanding of a very key fact, or a clearly erroneous understanding of what the law requires? So I think that's, been part of the history, is that we don't want to second guess juries, but and most of the time we think juries get it right. At least a lot of judges, the judge-jury agreement is very high. But we sometimes don't have confidence, because if we don't actually understand what the rationale for the jury decision was, that I think it tends to undermine, some of the public trust and confidence that this is actually a fair and unbiased process. And I'd add one more thing, and I think maybe this gets into other issues that we want to talk about in terms of the system, systematic bias, systemic racism. Is the jury, of course, is highly dependent upon who's actually eligible and available to serve as jurors. And that's a whole process that over time, who is excluded from the process, either because they are not qualified, non-citizens, in many states, people who've been convicted of felonies. Many people can't serve for financial reasons or transportation, having to do with socioeconomic policies that disproportionately place barriers for people of color. And so those are the types of things that the jury itself doesn't appear on the surface of it to have sort of built-in systemic racism, but certainly some of the practices about how we actually summon and qualify and make the jury system accessible for all citizens can exacerbate some of those issues.
Paula, you raised so many key issues, and we'll be unpacking some of those, not only as they apply to juries, but our whole justice system as we go into this conversation. Where I'd like to take this next is really piggybacking off of the issue of juries. So juries give us confidence that our peers and our community have a voice in the outcome that we arrive at through the justice system. But as we learned from Laura and Carlton's conversation earlier today, there are other places where we need a public voice as well. And one of the things that came up was prioritizing the finite resources of the justice system. And it makes sense that communities would have some sort of a voice in that. Brandon, I'm wondering, what are some other ways that community voices should be considered in our criminal justice process, other than juries?
Oh, of course. And, and I think that this gets to, in some ways, a reason why we don't have more jury trials, because we have dependent so much on a punitive system that denies people their basic rights, exposes them to extraordinarily extreme sentences, and essentially coerces them into pleading guilty, such that on the criminal side of things, over 95% of cases are resolved by plea bargain, not by a jury trial. And so when we think about where the community fits into this equation, I think we have to be far more inclusive. And Michele, I think you mentioned earlier, people in communities want to be safe. It's a basic feeling for all of us. They deserve to actually be safe and to be heard on what it means to be safe in that conversation. And so what we find increasingly is that communities want real solutions. They want to know that people in charge, politicians, court system, are really investing in things that actually make them safe, and are increasingly turning away from punitive solutions like policing and mass incarceration in doing so, and wanting to explore non-punitive approaches. I mentioned I work a lot on bail, and I think this is a place where we are seeing a lot of this motivation, and it's also, fortunately, backed by current law. Under U.S. Supreme Court precedent, release should be the norm. And I think communities are now increasingly aware that when you put somebody in jail prior to trial, it has not only extreme individual consequences for that person, making them more likely to plead guilty to a crime, making them more likely to receive a harsher sentence, but it also has familial impacts in terms of perhaps losing custody of a child, losing housing, and then community level impacts where you have a removal of population into jail that's unable to contribute to the wealth of the community writ large. And so, those communities are now beginning to really demand that we have increased release pre-trial, that we enforce the presumption of innocence, and that we also invest in the community's ability to help people succeed when they are released prior to trial. And so things like community bail funds, community pretrial services, where we are enabling the community to really engage in this process of making sure people can come back to court successfully and complete their cases. I also want to shift gears slightly here and think about the fact that next week will mark the 60th anniversary of Gideon v. Wainwright, which, to oversimplify a little bit, guaranteed the right to a lawyer if you are charged with a crime and cannot afford your own lawyer. And sadly, to this day, we have never lived up to the promise of that Supreme Court decision. There are, even in, say, places like Oregon, hundreds of people right now who are waiting in jail without a lawyer and who've been there for weeks, months, and in some cases, years, simply because the system doesn't have enough lawyers to provide in a timely fashion. Now, we tended to look at that as a funding issue, that we need to put more money into the public defender function, and that is certainly true, but it is also true that this is indicative of the fact that we have too many cases in the system, and that it's not simply a funding problem. It's, again, a systemic and structural problem with over-prosecution, over-detention, and the like, where if we were to shrink the number of cases in the system, much in line with demands from community to be less punitive, then we would also see a reduction in the demand for public defenders, for prosecutors, for all the other things that have helped to create this assembly line system of justice, where we really are relying too much on mass incarceration to provide safety, when we know that other means are not only being demanded by communities, but can also deliver those ends much more effectively.
So as a practical matter, how do we start making that shift? How do we learn what the community values, where the community would like to see the enforcement resources and where the community would like to see some of these alternatives, and actually put them into place so that we start crafting appropriate, just results for the people that are right now being engaged in our legal system?
I think at a very basic level, one thing is to listen meaningfully. We and I mean, not just us, but many in this space have a saying of those closest to the problem are closest to the solution. Now, that doesn't mean that if you go to a community, you're going to magically get a set of solutions to these problems. And what it does mean is that government officials have to be intentional about spending their time and resources actually collecting input from the community. And I should say communities, because it's a very complicated question there, but getting some sense of if they're asking for more policing in a neighborhood, to get underneath that and say, what is your actual concern? Is it teenagers who have been denied after school programming because of the pandemic? Are there other dislocations that are at work here that we could use to then address those concerns? And then actually making real investments in the community, as in dollars and cents, in saying, let's set up structures within the community, run by the community, that can help us address this issue. And that's not just pie in the sky thinking. We have years worth of great research that, along with policing and other issues that helped to drive down crime after the 90s, community groups played a central role in helping to drive down crime, and could do so in the future, once again, if we were able to make the commitment of actually funding them at a sufficient level.
And not that I'm trying to say what Laura would have commented on, but I suspect that if she were still part of our discussion right now, she would say that when you gather community, you have to have enough seats at the table, true seats, true participation. So we need to be very intentional about making sure that we are including individuals who have been marginalized, maybe are suffering from some of these collateral consequences, making sure that their voices at the table too, because sometimes their voices are missing. Excellent comments, Brandon. Kyle, I know you have worked with community voice in some of your police practices efforts. Can you maybe comment from that perspective on how we can continue to partner with community to make sure that the justice that our system is delivering feels just to them as well?
Yeah, so I'm a member of the City of Columbus's inaugural Civilian Review Board, which was launched in 2020 after a charter vote in 2020. And I was also part of the work group on that Civilian Review Board. And so been a couple of years on this board and really running into a lot of these issues about not just thinking about policing practices, but to Brandon's point, what does it mean to keep our community safe? It's understanding that all of these issues are at an intersection, and it's not just policing over here. It's also thinking about resource allocation, investment in community. And so, to your question, both on the policing practice point, but also on the community voice side, you have to have things like actual engagement in community, right? Because oftentimes there is an announcement of a big initiative or a big policy that may or may not have had community engagement to begin with. But certainly when it goes to the implementation process, instead of just rushing through that and just getting something done or announced, we need to actually step back and engage and be willing to listen to feedback and to critique. And there are often times when people shy away from that real authentic community engagement for fear of slowing down whatever policy that they wanted to implement anyway in the first place. And so you don't always have that authentic engagement in community that is needed, which is also why, in addition with engagement, you need accountability and you need transparency. All too often, people seem allergic to accountability. But the only way in which we are going to actually solve some of our challenges and actually have real community voice is to recognize that we have complex, challenging issues that we're dealing with on a day-to-day basis. But we also know that it's not like the solutions don't exist. There are best practices. There are examples, not only in our communities, but in communities all across the country, of how to actually have authentic engagement, community voice, and actually having people with a seat at the table, but not just, for show, actually having a seat at the table and having the ability to make a set of decisions to make an impact. And so when I think about community engagement as it relates to policing, as it relates to community safety more broadly, I think about our work on the Civilian Review Board. We have 11 members from the community that are supposed to represent the diverse voices and perspectives of the city of Columbus, and also are supposed to bring to the table ideas and solutions for reform and solutions for transparency, accountability, and oversight, and to make sure that people feel heard in the process. There's oftentimes that people have bad experiences within the criminal legal system, bad experiences interacting with law enforcement, bad experiences interacting with politicians and community leaders and policymakers, and feel that they don't have institutions that they can trust. And so as a result, these types of review boards, these types of community organizations, and to Brandon's point earlier, the types of community groups, the civic associations, the local organizations that are doing work on the ground, that are bringing community voice and frustrations and concerns and speaking truth to power is so critical. The challenge is, however, is that because the ways in which our systems are structured, oftentimes review boards, other types of organizations that are established to try to create systems of accountability simply don't have nearly enough power to really put in place the types of strategies you need to get long-term sustainable accountability and oversight. And so it's on us to create the types of review boards where we have process with community. We talk about what does it look like to file a complaint? If you feel like you had an experience that you want to file a complaint, how do we walk you through that process? And we have a Department of Inspector General's office that actually investigates those complaints. And then that is shifted along towards the review board to review those complaints. And then that's shifted to the safety director and the police chief. There are a set of layers and layers and layers. And so what's important is for people to recognize that this is just one part of a larger system. And so there will never be kind of this magic solution over here, but we do know that we have to change the way we think about safety. And we also have to change the way in which we invest in our communities, not just in punitive approaches, not just in disinvesting in communities, but investing in real resources, real access. And we also have to talk about wealth. Because if you don't have the economic security and agency, then you will not have the ability to make the types of engagements into these issues, because simply you're just trying to keep a roof over your head. And so we have to do a better job of making sure that people are truly empowered at the table, but have the supports they need and the resources to make the types of decisions we need to make a difference in our communities.
And, you know, Kyle, some of the challenges that you mentioned, I suspect, Paula, you face also, because when we are talking about assembling a jury of our peers, we are talking about representatives of community, particularly with elements of community that the defendant who's on trial is experiencing. So how does this show up in making sure that we can ensure people of their right to a jury of their actual peers?
Well, so that's basically my full-time job, and it's important to realize just how much upstream work is involved in actually getting a group of citizens walking up a courthouse steps on any given Monday morning for jury selection, and so it really starts at the beginning of who is in the community that you can call upon? What is your master jury list comprised of? Historically, for most of this country, they relied on the voters lists because it was easy. The qualifications for voting and the qualifications for being a juror were pretty much identical. So you could just take the list from the voter registrar and use that to summons jurors, and you didn't have to worry that you're going to get somebody who's not qualified because the voter registrar would have already done that vetting process. As it turns out, and what we know today is that the voters lists really grossly underrepresented people of color, younger people who were more mobile, lower socioeconomic income, lower education, and so that voter list was really, it wasn't inclusive of the population, certainly not of the population that was often on the receiving end of the criminal justice system. And so what we saw over the years is courts adding and supplementing the voters list with other types of broad-based lists to try and actually encompass a larger percentage of their communities. The most common one is driver's license and state income card holders, or state identification card holders. Other states use state income tax filers, unemployment compensation recipients, public assistance recipients. So those lists that are trying very hard to make sure that we actually have as inclusive a group in the community from which to draw. And then you use your random selection to actually select names. Now that's just the very first step. And then you have to go through the process of, are you statutorily qualified for jury service? And that's where we actually start to see some of the barriers that tend to pull out people, especially people of color and people of lower socioeconomic means. So you have to be a U.S. citizen. So if you're in a community with a large immigrant community that is part of your neighbors and part of your community, but they are automatically going to be excluded from consideration for jury service. People who have felony convictions are often excluded. There's some very interesting research that's been done over the last couple of years, really questioning the wisdom of felony exclusion rules, both certainly for voting, and I think that's gotten the biggest amount of attention, but also for jury service and some of the assumptions about, why shouldn't felons actually serve? They'll be biased against the prosecution. Well, actually, what the research that's been done has suggested that actually no, and they actually bring an awful lot to deliberations because they've lived the criminal justice system from the inside and have a much more nuanced understanding of their lived experience of what this actually means, both for the offender and for victims, and they can see through a lot of BS. So some of those assumptions are not really valid, and particularly when you think about sort of how do you integrate people and invest in your community. For the states that do regularly, don't disqualify on the basis of felony. The state of Maine, for example, there have been studies done, and for convicted felons to sort of be back in and given the responsibility of being a citizen and engaged in the justice system, it's kind of this redemptive experience, and they feel that much more invested in their communities, and that just has to be a good thing. To not continually keep people on the fringes of society because of something that they've done, sometimes in the very distant past. So some of those qualifications can really hurt, where the communities are coming from, and then just the conditions of jury service. There are still a number of courts that still have long terms of service, so you're on the hook for a week, 2 weeks, maybe a month of being called in and again. And so if you're an hourly wage worker, that may be too much of a financial hit if you're also trying to pay for rent and take care of kids and childcare and food and everything else that just get excused for financial hardship. So we're seeing a lot of courts that are starting to look at how do we reduce the burden of jury service so that people can. How do we increase the compensation, which is frankly pathetic, of what we pay jurors? Can we get our business community to support, basically reimbursing jurors at their full wages for at least some limited period of time? Keep in mind, most trials are relatively short affairs. You're talking 2 or 3 days, maybe a week, but we're not talking like long periods of time. And so just allowing for people to actually have the financial wherewithal to be able to participate in our justice system would be huge.
And really, I think some of the things that tie into community voice in all of its forms, physical barriers. So how many people that really need to be a part of the discussion don't have transportation, don't have childcare, If they're using public transportation, comparing how long it takes to get from point A to point B by bus or a series of buses that don't occur very often, versus a luxury that many of us may have if we just get into a car that reliably starts and has plenty of gas and we can get to where we need to go. We can afford the parking, whatever that looks like, especially in these urban areas. Parking can be a huge barrier. And have the means to get back home and make sure children are cared for. There's a lot happening. And so whether you're trying to look at these community engagement sessions or having people be able to physically come to jury, walking someone else's path and asking them what it looks like to walk their path seems to be critically important. Another thing, and this time is going by so quickly, I want to shift to something else that Laura and Carlton talked about. Laura suggested that we cannot simply conduct a blind pursuit of the law, that we really need to see the impact of our decisions. And I know this was a topic that all three of you touched on earlier in our conversation, but I want to bring that up to the focal point right now. And I'm going to stick with you, Paula, because I think there is perhaps a public illusion that everyone who has criminal charges filed ends up being in front of a jury or at least in front of a judge. And I think, Paula, you have some good statistics to give us a realistic picture of how many cases are going to trial, bench or a jury trial.
Yeah, it's kind of an irony today that we talk about trial courts, which is where trials take place, and they have almost disappeared. There are very few trials formally where you actually present evidence and law, jury or bench trials. Roughly, for the best that we know, about 2% of criminal cases end up going to a trial of some type, and a fraction of a percent of civil cases end up going to trial. Brandon, I think, touched on some of the earlier ones. Sentencing is a really big determinant of sort of what are the risks of going to trial, particularly with the way our plea bargain system works. There's actually sort of a plea penalty, or rather a trial penalty that can take place in that process, where if the prosecutors say, well, I will make a recommended sentence of, half of what the guidelines say if you're convicted at trial, or I'll reduce the charges to, these lesser includeds as opposed to what the indictment actually said, which, unless you actually have a really strong case for an out-and-out acquittal, most people are not going to take that bargain of sort of rolling the dice and, what will a jury actually do with this, when I can possibly, negotiate for something more. So it's like the whole right to a jury trial, has, I think, more perceived risk than is actually there. Juries actually do make a good decision, most of the time, not all of the time, neither do judges, neither do any of us. But the risk in terms of the penalty is substantial, and I think if we could actually work on the sentencing side of it, so that people who genuinely wanted to go to trial because they actually think that they are being overcharged, or that they do have a valid defense that would resonate with jurors, have the opportunity to do that. And part of that whole discussion of sort of having the community there is as much for the prosecutors and the judge and the public defenders, because this is sort of now it's sort of the default of, if you can't negotiate some sort of a plea ahead of time, you're going to trial. And I think it's really important to have enough trials taking place so that the parties there have an informed judgment about, if I reject this plea, what is a jury likely to do with this evidence? Because often, as we know, that some of the community views that say, yeah, we want public safety, but we also want you to not be wasting our resources on silliness and over incarceration and, all of the things that we've talked about earlier this hour. And say, yeah, we wouldn't actually convict on this charge. We might convict on a lesser included charge, or we might acquit entirely. And it's important for prosecutors and defense counsel and judges to hear that often enough so that when they are having plea negotiations, that those can be meaningful negotiations.
That makes perfect sense. And also, the pretrial detention issue. So if you're still being detained, right? So we have parents and siblings and, people that are trying to have jobs, support families. If they're being held in pretrial detention, the wait for the trial could be a factor. And oftentimes the right to a speedy trial is waived to give enough time to develop the evidence. But then the flip side is there's even longer pretrial detention. But let me turn it back to our experts. Kyle, I know you've done work with plea bargaining. And so if we don't have a case that goes to trial, either a jury trial or a bench trial, it's likely to be resolved through the plea bargain process. What do we need to be aware of and concerned about plea bargaining?
Yeah, so a lot of my policy work more broadly is looking at how these institutions interact as it relates to issues related to plea bargain, but also as it relates to sentencing, the initial charges, arrests. So when we look at it through these lenses, of course, there's a lot of research that looks into when you're thinking about arrest rates, what the initial charges are, what sentencing is like. And as we know, you are much more likely to be arrested, to be charged, to be sentenced more harsh if you are Black than if you are white in our criminal legal system. That is a fact at every step of the way that these disparities increase. But there hasn't been as much research on the pieces as it relates to plea bargaining and what that looks like and the decisions and determinations as it relates to racial disparities that persist. One of the recent studies that came out several years ago, and there's been more recent research on this, which is pretty fascinating to look at. One study in particular looked at court cases in Wisconsin, about 30,000 court cases in Wisconsin over a 6 to 7 year period, I believe. And one of the things that they found was that white defendants were much more likely, I believe 25% more likely to receive a reduction in the most serious initial charge than Black defendants. And we saw this happen time and time again when it comes to especially those with, if you're a white defendant or a Black defendant with no prior convictions, if you're a white defendant, you're much more likely to see your initial charges reduced. When you look into not just felony offenses, but when you look into misdemeanors, you see disparities even more increase when it comes to being a white defendant or a Black defendant. A Black defendant. A lot of reasons that can go into play with that, some of which where prosecutors and others might actually be using race as a proxy for thinking about criminality and recidivism, and understanding that the ways in which people's implicit biases can play a role in addressing and making those sets of decisions, but then also thinking about all the structural pieces that we talked about before, trust in the system, trust in the process, and navigating these processes. All of this points to a broader challenge that we have to face within our justice system. And that is understanding that if we have disparities at every single level, at every single point, then something is fundamentally wrong. And it is not simply a solution for us to just merely tweak the system here and there. We've got to address these pieces holistically, and we can see it in plea bargaining. And that's why it's really important for research, more and more research. That's why a lot of the work that we do, we focus on more broadly, is really thinking about evidence-based research. The folks are not just using their anecdotal experiences to speak to whether or not they believe something is going to happen, but we see the research, we see the patterns, and unfortunately, this persists all throughout our legal system in many countries or many jurisdictions and communities all across the country.
Fantastic. And, evidence-based practices, data, research. I know I'm in the state of Ohio, and this is being sponsored by the Ohio State Bar Foundation. And we've invited some panelists in our next panel today to address that exact issue. So I appreciate you bringing this to light on a policy level. Brandon, you've done work around sentencing. What else do we need to understand about sentencing and race?
Oh, I think Kyle covered it all. Seriously. No, I think in all seriousness, I think he did cover it well. What I would say, I think building off of what he said is, I think we really do have to understand that when we think about the racial disparities that we know exist in sentencing, when we think about just the disproportionate impacts of mass incarceration, we have to understand that this is a structural problem that's going to require structural solutions at a really deep level and even beyond the criminal legal system. And why I say that is, when we talk about this work, we often emphasize, for example, that there are huge disparities in drug enforcement, especially on marijuana. The ACLU over the past few years has released a report talking about the disparate policing and sentencing of people charged with marijuana, even though we know that Black people and white people use marijuana at the same rates. White folks might even use it a little bit more in certain cases, but certainly, they aren't where the police are devoting their attention, and they aren't getting the benefit of the DA's assumptions about who are good people who deserve a break rather than prison. But the deeper problem here is that if you were to look at the, roughly 2 million people now still in prisons and jails, the vast majority of them are there for what we consider, in many cases, to be violent offenses, right? And that if you were to, take out drug sentencing, you'd still be left with a mass incarceration crisis. And we have to ask ourselves why that is. And what's driving people into the system? What is causing violence? Why have we not been able to achieve true safety through this system of mass incarceration? And I think that's what we have to understand. Is like we've really taken this punitive approach, and when we talk about things like violence interrupters or alternative responses to people in crisis, we're always told you have to show proof of concept and you have to show that this actually works. And I always say, well, mass incarceration never had to show proof of concept. We just locked a bunch of people up and thought that would solve our problems. And it clearly hasn't. And it clearly hasn't solved the underlying problems of violence that we see every day. And so that's what requires the deeper look there. That when we talk about communities from which people are coming from, we talk about mental health care and the fact that so many people who are committing harmful offenses have unaddressed mental health issues. Before I came to the ACLU, I worked at the Equal Justice Initiative in Alabama, working for people on death row or children who've been put on life without parole. And I didn't have a single case where a client of mine wasn't dealing with deep, unaddressed trauma at some point in their lives, and kind of realizing that line between the perpetrator of violence and the victim of violence is maybe a little bit blurrier than what we like to admit. And so I think we have to realize that we can't solve all these problems simply within the bubble of the criminal legal system. We have to look beyond for those solutions.
Brendan, I really appreciate that. Oftentimes that I'm speaking, I get to talk about individuals who encounter the justice system, and they're really there primarily because of poverty or mental illness or substance use disorders. And we need to, there's not a formula of punishment that can change those underlying conditions. And so partnering with those community organizations, with treatment providers that can address those underlying conditions actually show much better outcomes. Well, we are nearing the end of our time, and I really appreciate how you have been able to open up our minds to parts of the legal system and justice system that we may not see, to helping us all understand ways that we can continue to build a more just system. And I always wonder, so what can we do differently tomorrow? We took out the time today to attend an event. It sounds like there's a lot of work to do. So we may feel like we don't know where to get started, or we're just busy getting back into our day-to-day business and catching up on all the emails and phone calls and things that, kind of built up in our absence. So I'm just asking, as sort of a call to action, what would you recommend very briefly that people attending this program can do, even starting tomorrow, to start making a difference? And I will let you decide who gets to go first.
All right. In the absence of anybody jumping up, I think knowledge is everything, and so I would actually encourage everybody who is watching, who's attending the program, check in with your local court and ask about the jury system. What is the term of service? How much are jurors paid? What are you using for source lists? How do you know, do you have a fair cross-section of the community regularly represented? And if not, do you know what the barriers are that are preventing that? Ask those questions and hold the courts accountable to, certainly don't let the seeking the perfect get in the way of simply being good. But we can all improve. But I think you have to stand up and say, we care about this. And, if there are places where it can be improved, let's figure out how to do that.
I'll jump in. I had a couple of thoughts on this. I know I need a quick one. I would say, one, I love the idea of just educating yourself. I would kind of add to that, getting out of your comfort zone. And so if you are a civil attorney who's used to handling that practice, go watch criminal court. You will be probably flabbergasted at what you see or what you don't see when you go there. If you are a public defender or somebody who's just doing criminal defense, think about running for judge. Think about running for office if that's an opportunity for you locally. If you're a judge, go visit a jail. Find out if you're somebody who makes decisions about who's going to be released, figure out where they're going and see it for yourself. So just, again, getting out of your own bubble and really seeing how these things operate.
Now, I'll just echo what they said on this, and especially when it comes to getting outside of your comfort zone. And it doesn't seem like a concrete solution, but really speak truth to power. Because at the end of the day, we know that the solutions are out there on so many of these issues, but it requires us to push back against those who are trying to continue to uphold the status quo. Because the fact is that there are many people who are profiting off of and doing just well off of the way the system currently operates. And it's as much as we want to believe that all of us are together in this and trying to stream in the same direction, we know that there are those who would really rather have the status quo stay where we are. And so it requires each one of us to speak truth to power, to step outside of our comfort zones, and to really have the difficult conversations, the challenging conversations, especially when people would like to ignore talking about issues of race. We've got to make sure that we don't ignore or erase that history, and we actually talk about race. We talk about racial equity, and we understand that this is not a zero-sum game, and we actually can do more if we have a more equitable approach to these things. But it requires speaking truth to power. So I'm just grateful to be here today.
Thank you so much. And Kyle, Brandon, Paula, I'm so grateful that you joined me for this discussion. I'm grateful that the Ohio State Bar Foundation and my fellow classmates picked this topic. And I would also add that if this program was helpful, it's recorded, and please tell other people about it so that we can spread the information and the inspiration that was shared today. Thank you all.
Thank you.
Thank you.
Thank you.